Hello everyone, I am Sampa Karmkar Singh, Assistant Professor Law at WBNUJS, Kolkata. Now today we are going to talk about a module titled as Prevention, Detection and Prosecution of Cyber Criminals. The objectives of this module is to inculcate within the readers in-depth knowledge of laws related to cybercrime and to explain basic concepts required for better understanding of prevention, detection and prosecution of cyber criminals. After going through this module, the readers will have a comprehensible understanding of the concept of cybercrime, laws relating to cybercrime, the prevention, detection and prosecution of cyber criminals, cyber jurisdiction, cyber appellate tribunal, security education and awareness about cybercrime. Before directly moving to the topic, we first need to know briefly about the concept of cybercrime as a growing global challenge. Cybercrime, as we know, is an emerging area of crime which requires lots of attention because of its global feature. According to the Salvador Declaration on Comprehensive Strategies for Global Challenges, the development of information and communication technologies and the increasing use of the internet create new opportunities for offenders and facilitate the growth of crime. Cybercrime is both a social and economic phenomena. The Convention on Cybercrime, popularly known as the Budapest Convention, is the first international treaty seeking to address internet and computer crime by harmonizing national laws, improving investigative techniques and increasing cooperation among nations. In 2013, United Nations Office on Drugs and Crime has also prepared a draft report titled Comprehensive Study of Cybercrime to examine the options to strengthen existing and to propose new national and international legal or other responses to deal with cybercrime. Information technology sector is an engine for economic growth and prosperity and has become one of the most significant growth catalysts for the Indian economy. In addition to fueling India's economy, this sector is also positively influencing the lives of the people through direct and indirect contribution to various socio-economic parameters, such as employment, standard of living and diversity. The sector has played an important role in transforming our country's image to that of a global player in providing world-class technology solutions and business services. In India, the Information Technology Act of 2000 and its corresponding rules mainly provides ways to deal with cybercrimes. It is interesting to note that the expression cybercrime has not been defined by the Information Technology Act of 2000, which addresses cases related to cybercrime along with Indian Penal Code. However, the Act provides legal recognition for transactions carried out by means of electronic data interchange and other means of electronic communication, commonly referred as electronic commerce. Cybercrime is a crime that uses a computer as its primary means of commission and also includes any illegal activity that uses a computer for the storage of evidence. It is a crime with global dimension. To combat and prevent cybercrime, a stringent legal framework for the criminalization of cyber criminals and the proper implementation of existing laws is the need of the hour. Proper investigation and prosecution may result in an effective response to cyber crimes. Over the years, information technology has transformed the global economy and connected people and markets in ways beyond imagination. With the information technology gaining the center stage, nations across the world are experimenting with innovative ideas for economic development and inclusive growth. It has also created new vulnerabilities and opportunities for disruption. The cybersecurity threats emanate from a wide variety of sources and manifest themselves in disruptive activities that target individuals, businesses, national infrastructures and governments alike. Their effects carry significant risk for public safety, security of nation and the stability of the globally linked economy as a whole. Some underlying features linked to cybercrime are access to global victims, identity anonymity and socio-economic factors. Lack of deterrent factor, increasing use of internet also facilitate cybercrime. There are different categories of cybercrime as cybercrimes against nation, which includes cyber terrorism, damaging critical information infrastructure, etc. Cybercrime against person, which include online harassment, cyber stalking, this has also been included in IPC, obscenity, etc. Cybercrimes against property includes financial crimes, cheating, online or illegal fund transfer, etc. The list of crimes does not come to an end here, but there are some other forms as well. For instance, business email compromise. BEC is defined as a sophisticated scam targeting businesses working with foreign suppliers and businesses that regularly perform wire transfer payments. The scam is carried out by compromising legitimate businesses' email accounts through social engineering or computer intrusion techniques to conduct unauthorized transfer of funds. Email account compromise EAC. It is a sister scam to BEC. Differs from BEC that is target individual or individual professionals instead of businesses. EAC is defined as sophisticated scam that targets the general public and professionals associated with but not limited to financial and lending institutions, real estates, companies and law firms. Ransomware is a form of malware that targets both human and technical weaknesses in organizations and individual networks in an effort to deny the availability of critical data and systems. Ransomware is frequently delivered through spear phishing emails to end users, resulting in the rapid inscription or sensitive files on a corporate network. When the victim organization determines they are no longer able to access their data, the cyber actor demands the payment of a ransom, typically in virtual currency such as Bitcoin, which is tougher to trace than regular currency, at which time the actor will purportedly provide an avenue to the victim to regain access to their data. Recently in 2017 itself, the malicious software WannaCry has infected thousands of computer systems in 150 countries. This attack is a frightening reminder of the vulnerabilities of a connected world. The cyber attackers are yet unknown. The Information Technology Act of 2000. The IT Act of 2000 provides ways to deal with cybercrime. It offers the legal framework so that information is not denied legal effect, validity or enforceability solely on the ground that it is in the form of electronic records. The Information Technology Act of 2000 seeks to empower government departments to accept filing, creating and retention of official documents in the digital format. It has also proposed a legal framework for the authentication and origin of electronic records, communications through digital signature. Now, section 2(1)(p) of the IT Act defines digital signature. In India, we need to put in place better legislation, improved criminal justice system and a strong regulatory enforcement system to prevent, detect, investigate and prosecute major economic crimes including cyber crimes, as the criminal justice system of our country is less effective in handling such cases. The object of IT Act is legal recognition to transactions carried out by means of electronic data interchange, recognition of electronic communication, recognition to electronic commerce, sanctity to storage of information and electronic filing of documents. It also talks about amendment in related laws. In 2008, Information Technology Amendment Act has been enacted to cater to the needs of national cybersecurity by addressing host of issues such as technology related cybercrimes, critical information infrastructure protection, data security and privacy protection. Organized crime is fast growing and targeting the exponential growth of online identities and financial transactions. Indian Computer Emergency Response Team has been operational as a national agency for cybersecurity incident responses. It has established operational linkages with overseas computer emergency response team and cybersecurity professional organizations to enhance its ability to respond to the cybersecurity incidents and take step to prevent recurrence of the same. There is a need to address compliance requirements to international standards and best practices on security and privacy. As such, there is a requirement for a comprehensively framework that enables compliance within the country and provides assurance on compliance to outsourcing organization and rest of the world. A sound legal framework and effective law enforcement procedure are essential in deterring cybercrime. In this direction, a recent amendment to the IT Act provide for an excellent means to enable adequate trust and confidence in the online environment and enhance law enforcement capability to deal effectively with cybercrime. Now, India has once again adopted an ambitious technology driven project named Digital India. Even Digital India has been heading towards rough waters due to lack of clear policies and implementation plan. It is said that prevention is better than cure. So, priority should be given to information campaigns and prevention of cybercrime. Dr. Gulshan Rai Committee was constituted by the Ministry of Home Affairs in 2014, which submitted its report on roadmap for effectively tackling cybercrimes in the country. Key recommendations of this committee to prevent cybercrime are: establish a new Indian Cybercrime Coordination Center. This center would check attempts of international gangs to penetrate Indian government official communication network. Devise an advanced application for social media analytics to monitor social media platforms activities related to ministries of home, external affairs, defense and other government organizations. Now, it also talks about reduce government's dependence on foreign servers and ensure one dedicated source gateway, secure gateway for all government communication. A separate agency for online cybercrime registration, monitoring and integration of CCTNS, that is crime and criminal tracking network system, and the data with the same. Amend the Evidence Act to suit the current requirements, and finally prosecute the cyber crimes. Sometimes sensitize the states by setting up cyber forensic laboratories in states along with workshop and international cooperation. Cybercrime is a global threat, as cyber criminals and internet both are beyond the control of national borders. Interestingly, the physical location of victims, perpetrators and relevant evidences for cybercrime is transnational in nature, making the practical application of extraterritorial legal provisions rather ineffective. Whilst an offender may be apprehended in one jurisdiction, the digital evidence required to initiate an investigation may reside in another country. Cybercrime has a virtual nexus with various parts of the world involving multiple parties. The question here is, if one party wants to sue the other party, where can he sue? As the traditional requirement is, either it would be the place where the defendant resides or where the cause of action arises. However, it is still unclear in the absence of clear guidelines as to how these are to be determined in relation to cybercrime. Generally, when a forum is torn between two conflicting laws, it often chooses to apply its own law, as it will always be most familiar with the nuances of its own law. However, such a rule may lead to a situation which is not entirely equitable. For instance, plaintiff would sue in nation where the legal condition is unfavorable for the defendant, or due to absence of resources, the defendants are unable to respond. Now, take another example. If a business is banned or regulated in certain areas like gambling, then it may be necessary to identify all users before they can be permitted to engage in transactions, and to prohibit transactions with certain users and in certain jurisdictions. However, the practical application of this is very challenging. While dealing with cybercrime, the investigating authorities have to face numerous problems. For instance, the physical location of victim, perpetrator and evidence all are not found in one place. Perpetrators have access to global victims as the nature of the crime is transnational. They can easily hide their identity and act anonymously. Unfortunately, till date, there is no foolproof technology to combat this menace in its entirety. With plethora of advantages through internet, lots of disadvantages also are attached with it. The legal regime is still not sufficient and stringent enough to deal with such cases, though we have some good laws with us like Information Technology Act or Indian Penal Code, etc., but the application and implementation of these laws is still a big challenge in the field of cybercrime. The interconnectivity of the global economy enables criminals to operate trans-jurisdictionally with discrete element of their crimes speckled widely across the globe in both time and space. To prosecute cyber criminals, it is necessary to first detect the criminal, and that itself is a tough task. Now, about the cyber jurisdiction, where to sue? This is very important question. The central government may, by notification in the official gazette, appoint a controller of certifying authorities and also deputy and assistant controllers whose qualifications, experiences, terms and conditions of service may be prescribed by the government for discharging the functions provided under section 18 of the IT Act. The Act empowers the central government to appoint an adjudicating officer to hold an inquiry as to whether any person has contravened any provision of the Act or any rule, regulation or direction or other made thereunder which renders him able to pay penalty or compensation. The adjudicating officer appointed under the Act can exercise jurisdiction to adjudicate matters in which the claim for injury or damages does not exceed rupees 5 crore. In respect of claim for injury or damage exceeding rupees 5 crore, the jurisdiction shall vest with the competent court. Any person aggrieved by the order made by the controller or by an adjudicating officer appointed under the Information Technology Act can prefer an appeal before the Cyber Appellate Tribunal within 45 days of receiving the copy of the order of the controller or the adjudicating officer. Cyber Appellate Tribunal has been established under section 48(1) of the Information Technology Act of 2000. This is the first and the only cyber appellate tribunal in the country. Initially known as the Cyber Regulations Appellate Tribunal, it started functioning from October 2006. The Cyber Appellate Tribunal has, for the purposes of discharging its functions under the IT Act, the same powers as are vested in a civil court under the Code of Civil Procedure. At the same time, the tribunal is also guided by the principles of natural justice. The Cyber Appellate Tribunal has powers to regulate its own procedure, including the place at which it has its sittings. Every proceeding before the Cyber Appellate Tribunal shall be deemed to be a judicial proceeding. The statistics from National Crime Records Bureau of 2014 shows the total number of reported cybercrime cases in India and also reveals the low conviction rate in such cases. Now, I will discuss some cases related to cybercrime. These cases have shown how the judiciary has responded in cybercrime cases and unconstitutional provisions from acts were struck down. Honorable Supreme Court has time and again given judgments to suit the changes in the field of cyber law, as it is an emerging area and lots of research is still required to develop suitable laws to cater its needs. In Shreya Singhal versus Union of India case, a writ petition was filed under Article 32 of the Indian Constitution, raising very important and far-reaching question related to the fundamental right of free speech and expression, guaranteed by Article 19(1)(a) of the Indian Constitution. It was contended that Section 66(a) of IT Act infringes the fundamental right to free speech and expression and is not saved by any of the 8 subjects covered in Article 19 subclause 2. Section 66(a) was not in the Act as originally enacted, but came into force by virtue of an Amendment Act. It was held that Section 66(a) of the Information Technology Act of 2000 is struck down in its entirety, being violative of Article 19 subclause 1(a) and not saved under Article 19 subclause 2. However, Section 69(a) and the Information Technology Procedure and Safeguards for Blocking for Access of Information by Public Rules 2009 are constitutionally valid. Section 79 is also valid subject to Section 79 subclause 3b being read down to mean that an intermediary upon receiving actual knowledge from a court order or on being notified by the appropriate government or its agency that unlawful acts related to Article 19 subclause 2 are going to be committed, then fails to expeditiously remove or disable access to such material. Similarly, the Information Technology Intermediary Guidelines Rules of 2011 are valid subject to being read down in the same manner as indicated in the judgment. In Kamlesh Baswani versus Union of India, it has been prayed to direct to block the pornography websites and platforms, links or downloading in order to prevent easy access and to take strict measure to prevent distribution and access to pornography, including measures regarding file sharing software, to adopt various measures towards improvement in the effectiveness of blocking child pornography on the internet and to take measures to eliminate child pornography. In Fatima Rizwana case, the apex court laid down the mode of trial of a case relating to cyber pornography. In Anwar PV versus PK Basir and others case, one of the principal issues arising for consideration is this appeal was the nature and manner of admission of electronic records. Electronic record produced for the inspection of the court is documentary evidence under Section 3 of the Indian Evidence Act of 1872. Information Technology Act of 2000 proposes drastic amendments to some of the sections in Indian Evidence Act. In respect of collecting electronic data and cases relating to cyber offences, cybercrime cases have witnessed a quantum jump over the past few years. These complaints are being received by hand as well as through post or emails and are generally related to social networking sites like Facebook, Twitter, YouTube. Besides fake email IDs, hacking of websites, email accounts, credit card frauds, internet banking frauds, then abusive, defamatory or threatening emails, etc. The evidence in such cases is required to be immediately retrieved and analyzed. Since the evidence pertains to emails, websites, chat rooms and databases has to be traced on the desktops, laptops as well as mobile phones. It is imperative that the data is retrieved at the earliest and following the prescribed procedure for its admissibility in courts. The origin of a disruption, the identity of the perpetrator or the motivation for it can be difficult to ascertain and the act can take place from virtually anywhere. These attributes facilitate the use of information technology for disruptive activities. As such, cyber security threats pose one of the most serious economic and national security challenges. Many cyber vulnerabilities exist because of lack of information and security awareness on the part of computer users, system network administrators, technology developers, auditors, chief information officers, chief executive officers and corporates. A lack of trained personnel and the absence of widely accepted multi-level certification program for information security professionals complicate the task of addressing cyber vulnerabilities. Spreading awareness about cybercrime and cyber laws will help people to tackle this problem. As there is lack of knowledge in this newly developing field, people do not know what to do, where to approach and what remedy is available. At least if these queries made clear with cases and relevant laws, it would be very helpful for the public at large. Large perspective. Prospective victims will also know their rights and also their awareness, there will be less chance to get victimized. So, security education and awareness should be promoted and the government has also taken positive steps in this field. The 11th and 12th 5th year plan provides for cyber security and as well as there is a standing committee report on cybercrime, cyber security and right to privacy which lays down key recommendations to tackle the issue of cybercrime. The recommendations are: first is establishing a national critical information infrastructure protection center, then constitution of cybercrime cells in each state, district and block, then connected to a centralized system, international standard organization certification, conducting extensive training programs to overcome shortage of security experts, auditors and skilled IT professionals, then funding for research and development, external hosting and new technology, periodic review of the provisions of IT Act of 2000, then signing of MOUs and international treaties to address cross-border challenges in cyber security, instituting a legal framework on privacy which is secure and people friendly, setting up of a grievance redressal mechanism by means of cyber appellate tribunal, helpline for common public to deal with cybercrime. We need trained personnel urgently, but unfortunately there is shortage of experts in this field and we are still in the process to train them. Government has taken several initiatives to educate officers who are dealing with such cases. The process of training and education is ongoing, so the officers should be trained periodically so that they are updated with the rapid change in this field which will help them to deal with cybercrime cases. Under section 70B of the IT Amendment Act of 2008, the Indian Computer Emergency Responses Team shall serve as the national agency for performing the following functions in the area of cyber security. First is collection, analysis and dissemination of information on cyber incident. Second is forecast and alerts of cyber security incident. Third, emergency measures for handling cyber security incident. Then fourth is coordination of cyber incidents responses activities. Fifth is issue guidelines, advertises vulnerability notes and white papers related to information security practices, procedures, prevention, responses and reporting of cyber incident. Fifth is such other functions relating to cyber security as may be prescribed. The promotion and publicity campaign would be very helpful to spread awareness and educate all about cyber laws. Mass communication may be used to make such campaigns successful at large scale. Promotion and publicity campaign include seminars, exhibitions, contests, radio, TV program, video or webcast, podcast, leaflets, posters, suggestions and award schemes. Lots of people get connected through the above mentioned approaches and can wage a war against cyber criminals. Collectively, to stop cyber crime, we need to equip ourselves with proper knowledge in this field. Otherwise, it would be difficult if not impossible to overcome this global challenge. Knowledge is the key to combat and prevent this menace. Major actions and initiatives for user awareness, education and training are promoting a comprehensive national awareness program, fostering adequate training and education program to support the nation's information security needs, for example, school, college and postgraduate programs on IT security, international standard organization certification, conducting extensive training programs to overcome shortage of security experts, auditors and skilled IT professionals. Even this initiative by MHRD to prepare a module is a welcome step in this regard, as the main motto is to spread awareness through EPG Pathshala. The cyberspace is borderless and actions in the cyberspace can be anonymous. These features are being exploited by adversaries for perpetration of crime in the cyberspace. The scale and sophistication of the crime connected in the cyberspace is continuously increasing, thereby affecting the citizens, businesses and government. As the quality and value of electronic information have increased, so to have the business models and efforts of criminals and other adversaries who have embraced the cyberspace as a more convenient and profitable way of carrying out their activities anonymously. Millions of people throughout the globe are victims of internet crimes. The criminal justice system is less effective, if not ineffective, in handling cyber crime cases. India needs to put in place better legislation, improved criminal justice system and a strong regulatory enforcement system to prevent, detect, investigate and prosecute cyber crimes. All countries in the world need to work together on international laws, conventions and other measures to stop cybercrime. The only means to combat and prevent cybercrime is to adopt appropriate transnational measures with holistic approach. As cyber criminals becomes more sophisticated in their efforts to target cyber victims, we must also grow our capabilities to successfully combat and defeat them. The evolving nature of internet crime presents a unique set of challenges, as crimes often overlap jurisdictional boundaries and perpetrators can attack from anywhere on the globe. Therefore, to conclude, this can be said that a cyber criminal is here, there, anywhere, everywhere and yet nowhere. Accordingly, we need to design the preventive measures so that whenever and whoever the criminal is, he should not escape the liability. A strong legal framework and collective efforts from throughout the world will definitely provide a secure and safe cyber zone where the cyber criminals will fear to encroach upon. I conclude with this optimistic note. Thank you so much for your patient hearing.